ground.
Hey, this is Boyd Newton.
Don Singleton.
Sean Boyd.
Good morning, everyone.
Good morning, Your Honor.
Good morning.
My apologies for running a few minutes behind dealing with some technical issues, but I think we've got those resolved and we're ready to get started on our motions calendar. I think there are a couple of matters that were taken off the calendar, so I just want to make sure that no one's here on either of those. And that was position 3, Reginald Bush versus Schneider Hammers LLC. Anyone here on that? No. And then we've got position 4, Bueno and Finnick versus Tracy Embry. Anyone here on that? No, that's fine. Let's see if we have anyone here on position 2, Berkshire Hathaway versus Fumba et al.
Matthew Totten for Berkshire Hathaway, Your Honor.
All right. We have either of the defendants. I think we were going to drop. Going to drop one of the defendants, it's Fumba.
That's correct, Your Honor. And there was a motion for judgment on the pleadings as to the other.
Right. Neither one has been responded to. I've seen the answer from Olasunkanmi Sunmonu, and it does not raise a sufficient defense, so that motion is granted.
Thank you, Your Honor.
And I believe, go ahead.
I'll send over a proposed order to your chambers.
All right, very good. Send it to Mr. Townsend and we'll get it entered.
Thank you, Your Honor.
All right, you may be excused.
Thank you.
All right, so let's go to position 1, Alva Hill versus City of Atlanta and Nico Flores. I have a renewed motion for sanctions for spoliation.
Yes, good morning, Your Honor. Don Singleton here, along with my co-counsel, Mr. Boyd Newton, for the plaintiff Alva Hill.
Good morning, Your Honor. Alicia Marie Nyer here on behalf of the City of Atlanta.
All right. So, Mr. Singleton, your motion, I'll let you start things off.
Thank you, Judge. Your Honor, what I'd like to do is just begin with a few minutes of sort of some procedural history to bring the court back up to date as to what has occurred with this case and what has led up to us filing this renewed motion for sanctions for spoliation. Just briefly, the complaint in this case was filed in August of 2017. An answer was filed in September of 2017. In August of 2018, the plaintiff filed her original motion for sanctions for spoliation of evidence, and the defendant city responded to that motion in September of 2018. And of course, that motion and what we're here to talk about today is the destruction of the video from the crash, and that's the subject of this case. In January, on January the 11th, 2019, the court may recall that oral argument was held on that original motion for sanctions for spoliation of evidence. And at that time, an order was not issued, but my recollection, and again, I'm speaking today about that motion off of my recollections. Perhaps the court has notes on it, but my recollection is that the court did find that there was spoliation, that the city allowed this video to be destroyed. The court did not find it to be willful to the extent that the court was willing to strike the answer at that time. However, because the city had implied at that time that they would most likely be admitting liability, the court stated at that time that the court was going to withhold a ruling and wait and see how the evidence came in at trial and rule at that time. And that made a lot of sense at that time based upon the city's sort of implication or representation that liability was most likely going to be admitted. Now, since that time, and what brings us back here today, let me focus on that. So since that motions hearing in January of 2019, we were placed on a 2-week trial calendar in February of 2020. In January of 2020, the defendant identified at the last minute its expert, Dr. Jake Fleming, a radiologist who was going to testify that the collision did not cause the plaintiff's need for her surgery. The court held a telephone conference regarding the late identification of Dr. Fleming and continued the case from the February 2020 trial calendar. In May of 2020, the plaintiff filed her Daubert motion to exclude the testimony of Dr. Jake Fleming. And the court has since ruled on that. But why I bring that up and what is important here is that when the city responded to the plaintiff's Daubert motion, the city gave again a preview of what its defense would be in this case. And the city stated, quote, "This is a personal injury action that arises out of a low impact motor vehicle accident involving the plaintiff and the city of Atlanta police officer." The defendant stated that the collision resulted in slight damage to the plaintiff's car. And they further stated, quote, "Thus a portion of defendant's liability defense strategy, they hired Dr. Jake Fleming, essentially to say that minor low speed impact could not have caused the plaintiff's need for her surgery." Following that, the plaintiff submitted requests for admissions to the defendant. And those are attached as our Exhibit A to this renewed motion, as well as the city's responses. But the city denied that the plaintiff was exercising ordinary care for her own safety at the time of the collision. The city denied that the plaintiff did not contribute to the cause of the collision. And the city denied that Officer Flores was the sole proximate cause of the subject collision. And those responses are attached as an exhibit to our renewed motion. So again, clearly the city has made clear to us what their defense is going to be. They're going to continue to deny liability. They're going to continue to blame the plaintiff for her actions or inactions that day. And that has been the testimony of Officer Flores. So just to briefly remind the court of the facts surrounding this collision. And again, I know all of this has been heard in the past. I want to make sure I focus on what the court wants me to focus on, but briefly, the crash was a rear end collision. Officer Flores was driving 89 miles per hour at the time. He says he was chasing after or trying to catch up to an alleged carjacking. At the crash site, we have Officer Crystal Young, who comes and investigates the crash and writes up the motor vehicle accident report. Officer Young is a co-worker of Officer Flores. Officer Young, in the accident report, she speaks to all the witnesses. Officer Flores says it happens one way, in that the plaintiff moved over in front of him and that he blames the plaintiff for her actions. The plaintiff says that Officer Flores didn't give her time that it was essentially she moved over at the same time he moved over, and the collision occurred. Officer Flores in his deposition denied he was traveling 89 miles per hour. Also at the scene, we have Officer Flores' supervisor, Sergeant Jeremy Mason, who comes to the scene. At this point, Sergeant Mason reviews the video. Again, the crash was all captured on video. The events leading up to the crash and the events just subsequent to the crash, all captured on the WatchGuard in-dash video of Officer Flores. Sergeant Mason arrives at the scene. He watches the video with Officer Flores. He then, the same day, writes up a memo, as he's required to do because this is an officer-involved collision. He writes up a memo where he finds, and again, memo is attached as an exhibit. He finds Officer Flores was traveling at 89 miles per hour. He does find that Officer Flores was at fault. Again, Officer Flores denies all of this. The city continues to deny all of this and continues to blame the plaintiff. So now we have the investigating officer who investigates the crash also notes that all three passengers, or the driver, Plaintiff Alba Hill, and her two passengers all complain of injuries, all leave the scene by ambulance. She does not review the video. She does not issue a citation to her coworker, Officer Flores. Following that, the video disappears. Now that was all, and I'm sure that the court recalls, that was all heavily briefed and heavily argued at the first hearing in January of 2019. So what I'd like to do, unless the court wants me to readdress that, is kind of fast forward to why we have filed this renewed motion and why we believe the plaintiff has been prejudiced and what it is that we're actually asking for.
Before you go to that, refresh my recollection. There is no evidence that the city intentionally spoliated the evidence, right?
That is correct. This was more of misfeasance or negligence in the fact that they allowed this video to disappear when they could have easily saved it. And in light of the fact that there is in fact a duty under this standard operating procedure, which specifically mandates that these such videos be saved.
You say that they could easily have saved it. So how would they have easily saved it?
Yes, Your Honor. And if the, and again, just so the court is aware, those facts concerning that question and that argument was, those facts were heavily briefed in our first papers when we originally filed the motion. But to state it simply, the SOP says they must save the video. At that time, it was a DVD system. Between the time the SOP was written and the date of this crash, they had moved to what they contend was a more updated system. The point was that the video was saved on a thumb drive within this WatchGuard system. Once this crash occurred and the city realized within 2 days following the crash, you've got a Sergeant Grigsby whose job it is to preserve and get this video. He began sending emails to the people in the technical department, it's called the EMU department, saying, hey, we've had a problem with the WatchGuard system. It did not download or upload this video as it should have. We need you to send us a tech. There was an exchange of emails. All of that was all documented and briefed in our original motion.
Yep.
The bottom line point that we were trying to make was if someone had simply gone and removed the thumb drive from the WatchGuard system, which again, there's testimony and evidence that that could have easily been done, we would still have the video. And in fact, the SOP mandates that the video should have been saved. So to answer the court's question, it was a thumb drive that could have been removed from the system and stored and later retrieved, downloaded, or whatever they could have done with it.
All right, you have sufficiently refreshed my recollection on that.
Thank you, Your Honor.
All right, so tell me about the prejudice.
I'm sorry?
About the prejudice.
Yes. Thank you.
Prejudice to your.
Yes. So in light of this, and in light of this evidence, we know that the defense has, we know what the defense is going to be. Blame the plaintiff, because they've stated it in their responses to various motions and briefs, that the plaintiff was at fault. Flores is going to testify to that. Officer Crystal Young, who investigated the crash, could testify to that. We don't know exactly what the sergeant would say, but all of that evidence is mounted up against the word of the plaintiff, who is going to have to recall these events and the severity of the crash through looking in her rear view mirror. The city wants to say that this was a slight impact that caused very little property damage simply because they have one photograph of the rear of the plaintiff's car. The prejudice is this: the plaintiff can't show the jury the video of the events leading up to the crash. And the plaintiff will have to try to describe all of this, of what she saw in her rearview mirror versus the testimony of these other officers. The video would have shown the actual collision and the force of the impact, and it would have shown how hard the impact was. And now the plaintiff has to just rely on her verbal description. We know that the defense claims it's a minor impact. That's what they hired their expert for. And they're going to say that the plaintiff's car proves that it's a minor impact.
Well, let me stop you there. So there is evidence, right? There is independent evidence of the damage to at least one of the vehicles. Is there not?
Your Honor, there is a photograph of the rear of the plaintiff's car, and there is a photograph of the damage to the police cruiser, which I would add was disabled at the scene and had to be towed from the scene. I guess the point is that the plaintiff is now prejudiced by virtue of the fact that the video of what occurred actually tells the story and is the best evidence. And the city, if allowed to continue to argue this and present evidence to this, gets one over on the plaintiff and has an unfair advantage by virtue of the fact that they spoliated this evidence that would otherwise tell the story. And it can't be cured. So if we start,
isn't there other independent evidence of the speed and severity of the collision? It sounds like there's some vehicle sort of black box data in the record. And I think you referred to it in saying 89 miles per hour. And I think the defendants have referred to some exceedingly small number, like 8 or 9 miles per hour. Isn't that independent evidence out there of how severe the collision was?
Yes, Your Honor, I would agree. And where we get that number is, so following the crash, the Office of Professional Standards, I can't remember the name of it, conducted an independent investigation into the crash. And as part of that investigation, they pulled data from the AVAIL system. AVAIL is an acronym for something. And that is where you get this telemetry, this GPS data, which shows, among other things, the speed of the police cruiser just prior to the impact of the collision. And that's where the 89 mile per hour number comes from. And that's what other officials within the City of Atlanta Police have testified to.
So where does I think the city came back with a number of 8 or 9 miles per hour. Do you know where that comes from?
I don't recall that, Your Honor. I haven't,
Okay,
I don't
maybe-
believe I've seen that in the papers.
All right, maybe that was a typo.
So I'm just gonna, and I'm gonna wrap up here shortly, but the Court of Appeals has set out this 5-part test, which both parties have briefed. So we've talked about the prejudice to the plaintiff from the destruction of the video, and that it cannot be cured. That's the second part of the test because the video is gone. The third part is practical importance. You know, the video shows exactly how the collision occurred. The plaintiff has the burden of proof, of course, to prove negligence and causation. And the city gains an unfair advantage by virtue of the fact that the video is now missing. The plaintiff's burden on causation and negligence would be more easily provable if the video had been saved. And it would show, of course, the impact of the collision. And then the fourth prong is bad faith. And this is kind of what I'd like to focus on. After the crash, we know the 3 people in the car are all left by ambulance. After the crash, we know that Flores and Mason both watched the video at the scene. Despite having the video available, Crystal Flowers did not look at the video when she wrote up her report. And of course, you've got the duty for the city to preserve this video through the standard operating procedure. And yet they still spoliated the video after all of Sergeant Grigsby's attempts with emails back and forth to the EMU unit. And we think that that shows layer upon layer of bad faith of the city, and that they should not be allowed to gain an unfair advantage at trial because of the 5th prong, which is the significant potential for abuse. By the city continuing to deny liability in light of this mound of evidence to the contrary, they do gain an unfair advantage. We know that Flores continues to deny the speed and continues to deny the fault and continues to point the blame at the plaintiff. And that's what the city has stated in their responses to our latest 2 motions. So let me just get to what we're asking for. We know that this case at trial, what we're asking for is, again, for the court to reconsider striking the answer, because there really is no other way for the plaintiff to gain an equal footing at the start of this trial with this missing video, because we know what the defense is going to do. They're going to claim it's low impact. They're going to claim there's no way she could have been injured, that she didn't need the surgery. They're going to claim that plaintiff was negligent in her operation of her vehicle. She should have or shouldn't have done one thing or the other. So we're asking the court to reconsider striking the answer to allow plaintiff to gain an equal footing at the start of this trial. Alternatively, and I know that that's a big ask. So alternatively, if the court is not inclined to do that, then what we're asking is for some evidentiary rulings that the defense cannot argue or present evidence that the plaintiff saw Flores approaching in the right-hand lane and then merged over into the right-hand lane in front of Flores's patrol car. Secondly, we're asking that the defense cannot argue or present evidence that the plaintiff negligently caused or contributed to the collision. Third, we're asking that the defense cannot argue or present evidence that the collision was low impact. And finally, we would ask, and maybe this is something we consider at the time of trial, but a jury instruction with respect to spoliation. And that's it from us right now, Your Honor. That's what brings us back with this renewed motion.
All right. Ms. Nair,
Thank you, Your Honor. The plaintiff is asking for two alternative major asks, and I get it. If I were the plaintiff, I would be asking for the same, because they're asking that since the city has denied liability, that the court theoretically impose that liability upon the city through the ruling on evidentiary matters. And I do not believe that that would be an appropriate remedy for what has occurred for this instance.
so that brings me to the first question. What is the city's evidence of negligence on the part of the plaintiff here?
That the plaintiff veered into the oncoming, well, what is the evidence is the testimony of Officer Flores. That is the evidence.
All right, and so you're going to present that evidence when there is contrary evidence from his supervisor?
So the idea theoretically, as everything has been already laid out, is that that is his testimony. And so that is likely the information that we are going to present. And yes, there is testimony there is testimony that differs from his supervisor who had an opportunity to view, which actually supports plaintiff's position. And that's why I don't believe the plaintiff is prejudiced in this instance, because not only do they have the plaintiff's testimony, not only do they have the occupants of the vehicle's testimony, but they have another witness who they suppose, or who they
Let me stop you there. The city's got to have a position here. And you've got testimony from one city official that supports liability, and you've got another that contradicts liability. So you're intending to present evidence at trial on both positions?
No, I said the plaintiff has the opportunity to present that evidence if they seek to present that evidence.
So you're not going to present the evidence of what OPS found or what the supervisor said after reviewing the video. You're just going to present Officer Flores' position.
At this time, I can tell you that I have not gone through the full trial strategy to inform the court as to what exactly I am going to present at trial. So I can't, with any degree of certainty, tell the court what I'm going to present. However,
this is important, because I think this is important to the prejudice. And let me tell you why I think it's important to the prejudice. We've got other evidence, other independent evidence, not someone's testimony, but independent evidence of damages. We've got independent evidence relating to the severity of the collision, the speed the cars were going. We've got expert doctors that are going to testify as to the nature and the extent of the injuries. But we don't have independent evidence other than this Officer Flores and the plaintiff of how this collision actually occurred. And without that video, it's left up to the plaintiffs to offer the position, the testimony of the city's supervisors as to what the video showed. I mean, that's prejudice. I mean, you're going to have information, you're going to have testimony presented at trial that's in conflict to the evidence that one of the city's own witnesses says is on the video that we now can't verify. Do you understand? And do you tell me why that isn't prejudicial for that evidence to be missing?
is it prejudicial that the evidence is missing? I would concede, yes, it is prejudicial. Is it prejudice that cannot be cured?
Okay, so tell me how the prejudice is cured on the liability standpoint.
I understand, Your Honor. The way that the prejudice is cured is through the testimony of the witnesses who did have the opportunity to witness the event. Not only is it the plaintiff, but the other occupants of the vehicle, and also the supervisor who viewed it, if they view that information to be in their favor. So ultimately, it appears that the plaintiff has the cards stacked in their favor because they have more witnesses on their end stating that the accident occurred one way, whereas the city has only one independent witness stating that the accident occurred in another manner. And so that does not state that there is prejudice that cannot be cured by independent evidence that is going to be offered at trial. And though plaintiff counsel would have to offer a witness from the city, I think that puts them in a better position to state that the information has some veracity for truth if they're arguing that to a jury. It does not prejudice the plaintiff for the plaintiff to not have a video when videos are something of the last 30, 40 years in patrol cars at that. And there have been plenty of arguments made prior to that time frame based on the testimony of the individuals who were present. So what we have is individuals who did witness the actual accident. We have medical records that either support or alternatively deny or go against what the plaintiff is saying, and that's going to be made through arguments. But I don't think that it rises to the level of prejudice that cannot be cured through the testimony of witnesses.
All right.
And what the ask of plaintiff is, they've already gotten the court to rule, and I apologize that I was out during your initial hearing on that in January. I was on maternity leave. The court has already limited what our expert is able to testify to, right? And so when plaintiff initially renewed its motion for sanctions for the spoliation, they were fearful of what the expert would be able to testify to. That has been cured. It is significantly limited as to what our expert is able to opine on. And so I don't believe that that is any longer a concern for plaintiff. The issue is that they're trying to cut all defenses that the city may have and may present by effectively saying that Officer Flores's testimony is therefore not allowed. And that then puts the city again at a disadvantage where the city is unable to present any sort of defense. So what we would ask is that the court deny plaintiff's motion for sanctions for spoliation if, in fact, well, we know spoliation did occur because the video it no longer exists. How the video no longer exists, there's a mountain of evidence that shows it was accidental at best. There's no reason that the city would not want to present this video because the video would in fact either support or help us to resolve the issue sooner rather than later. It's a car accident. We're not talking about the death of plaintiff. We're not talking about the death of an innocent bystander. We're talking about a car accident that occurred. And there's no reason for the city to, in bad faith, destroy any evidence that could support its position at trial. It's just not logical. There was a cyber attack that would have wiped away or did wipe away all access to things that occurred pre-2018. There was some issue with the WatchGuard system. And at that time, communications were made to the IT department to try and recover and reestablish anything that was there before. Unfortunately, this video was lost. This video was not recovered, but that does not rise to the level of bad faith on anyone's part. And why would we want to destroy a video that could potentially establish that the case happened exactly the way that our officer said it happened, that goes against what the supervisor said. The information is missing, and it is unfortunate, but it does not rise to the level of bad faith. And so when you're looking at the 5 factors that the court must consider in rendering its decision and using its discretion, is whether the party seeking sanctions was prejudiced. The court has found that there is prejudice. Or the court at least is inclining that there is prejudice. I respectfully disagree with that position. However, if there is prejudice, I believe that prejudice could be cured. And the practical importance of the evidence is little to no importance when you have witnesses, you have pictures, you have the testimony of the officer who was the supervisor, you have other evidence that can support plaintiff's position. And then whether the party destroyed the evidence, acted in good or bad faith, I would argue to the court that the city has always acted in good faith in regards to this incident. And then the potential for abusive expert testimony about the evidence was not excluded. I still am not sure what expert testimony is being offered here about this evidence. The evidence being who caused the crash. I'm not certain what expert testimony is being offered about that part of the trial. The expert that we're offering is going to discuss damages, not liability. And so I don't believe that in this case, sanctions are appropriate. And it appears that the only reason plaintiffs renewed their motion for sanctions was after they sought to get the city to admit liability through requests for admissions, and the city denied it. And that was their only reason for renewing this motion. There's been no other causing effect that has set this renewed motion in place. And so we would argue that, unfortunately, it does not weigh in their favor for sanctions to be imposed for this case. Thank you.
All right, Mr. Singleton, you get the last word on this.
Thank you, Judge. Just a few things. The city says in their argument that they wish they had the video. But their defense now hinges on, or they gain great advantage of the fact that there is not a video. And let me just point out, the video disappearing had absolutely nothing to do with the cyber attack. There's evidence in the record of that. There were other issues that came about concerning the cyber attack, but this was made clear in the testimony. This had nothing to do with the cyber attack. And again, you can tell the city again continues to try to minimize this as a low impact crash. The city refers to it as just a car wreck case. Well, guess what? This car wreck case that the city wants to minimize so much caused tremendous harm to my client, who had to undergo a very complicated surgery as a result of it. And yet the city wants to continue to minimize the impact and minimize the case. The city admitted that the plaintiff was prejudiced by virtue of the fact that the video is missing. She also admitted that the evidence was spoliated. So there must be a remedy for this. Otherwise, the city gains unequal footing from the start. The other two witnesses, there's no testimony from the other two witnesses. They didn't witness anything. They were facing forward. They didn't see anything. I suppose the only thing those other two witnesses could maybe talk about was the way their body reacted to the impact, I suppose. But there's no testimony from the other two witnesses. So again, we have Officer Flores, who's going to be painting the picture that the plaintiff did something wrong, when the video would absolutely contradict that. And the plaintiff has no way to overcome that. And that's why there's prejudice. And that's why a jury needs to be instructed on it in some way. And the city should not be allowed to present certain evidence because they gain an unfair advantage as a result. It's difficult. I recognize it. It's a situation that doesn't come up often. It's a tough nut to crack for the court. But that's our position, and we appreciate the court's time.
All right. So here's where I am on this. There's certainly spoliation here. Spoliation was not intentional. I think the city was in a difficult position with the technology, but I think there is slight negligence, and I think there could have been more diligence on the part of the city and its staff to, as I've read the affidavits and the sequence of events, I got the impression that these issues arise technologically and they get to it when they can. The city workers get to it when they can get to it. But you know, this was a prolonged issue, and it didn't get corrected as diligently as it could have. And I believe there are other options out there for preservation that just were not explored. I don't think there was any intent to destroy anything, but I do think there was some negligence involved with failure to preserve the evidence. So that leads us to the practical importance of the evidence and the prejudice. You know, the city argues that really there's no prejudice because we have the people who were there to testify as to what happened and what they did at the time. And because there's evidence of what the supervisor saw when they reviewed the video. I think that what the supervisor saw, the two officers who reviewed the video, I think that moves the needle a little bit. But in the end, Officer Flores can always say, well, they just got it wrong, or they didn't see what I saw, but I was there and I know what happened because I saw it firsthand and they didn't. And the fact that the video is not there, we have a pretty good idea of what, in this case, sometimes you don't understand what the lost evidence would have shown. But in this case, we do have a good idea of what the lost evidence would have shown. The lost evidence would most likely have shown that Officer Flores was at fault for the accident. And it's not there. And because it's not there, we have to rely on secondary evidence and witnesses who can be challenged as to their recollection of what they saw. It becomes hearsay and secondhand when we had something that was palpable and something that people could see with their own eyes. So I think there is prejudice, and I think the practical importance of the evidence is strong, especially when it goes to the main issue, the key issue of liability, who's at fault for this accident. So I think there needs to be some adjustment at trial to account for the destruction of that evidence. I won't go as far as to all the things that Attorney Singleton has proposed, but I will say that I believe the plaintiff is entitled to a spoliation charge, and the plaintiff is entitled to an adverse inference that the video would have shown, that the video evidence would have shown that Officer Flores was responsible for the accident. We can talk about the exact wording of that, but I think there needs to be an adverse inference and there needs to be a jury charge on spoliation at trial. That's my ruling. Mr. Singleton, if you would submit a proposed order to Mr. Townsend, copy Ms. Nair on it. We'll give you, we'll give you a few days, Ms. Nair, to take a look at the order and see if you have any issues with it. Let us know before we enter.
Thank you,
Yes,
Your
Your
Honor.
Honor, we will do that.
Thank you, Your Honor.
All right, thank you all, counsel. Unless there are any other questions, y'all can be excused.
Thank you, Your Honor.
Thank you,
Have a great day.
Do. All right. Let's talk now about Prescott et al. Versus Bell South. We have a motion for summary judgment. And we have a last moment and abbreviated response. So let's hear from Mr. Boyd. Are you going to handle
Yes, sir.
the argument on behalf of Bell South?
Yes, sir.
Your Honor, excuse me, Your Honor, is there a takedown on this one?
I would like a takedown. This is Harold Alexander Law Firm for the plaintiffs. I appreciate it.
Thank you.
Thank you.
All right, Your Honor. Just by way of background, this is a case that arises out of a service installation that a Bell South employee performed at a residence in Lithonia, Georgia in February 2016. And plaintiffs have claimed that during this installation, the employee had punctured a pipe behind a wall, which caused a slow leakage of water into the residence that resulted in property damage. In their complaint, which is a renewal complaint, they've alleged a claim for negligence against Bell South, for which they seek to recover compensatory damages, punitive damages, and attorney's fees and costs. Now, Bell South has moved for summary judgment on both the negligence claim and the claim for damages. With regard to the negligence claim, Bell South has moved for summary judgment because the plaintiff's admissions, by way of not responding to Bell South's request for admissions, demonstrate that there's no evidence to support that claim.
So let me
Bell South is all-
let me stop you there. Now, there was a motion
Yes, sir.
to compel that was filed,
Yes, sir.
and your motion was granted, and I ordered them to produce responses. Didn't they produce responses to the request for admissions in response to my order on the motion to compel?
Now, Your Honor, what I would say in response to that is twofold. First off, in our motion to compel, we had only moved to compel responses to the interrogatories and the request for production. And that's because under 911-36A2, those matters would automatically be deemed admitted once the plaintiffs did not respond to them. If the plaintiffs wanted to move to withdraw or amend those admissions, 911-36B required them to file a motion with the court asking for permission to do so and to make a certain showing. So to the extent that there was an order for the request for admissions, that wasn't part of our request. And secondarily, I would say the plaintiffs haven't met their burden to have those admissions withdrawn, and I can go into that further if the court would prefer.
Yes.
And secondarily, what I would say—
Yes, I would, because
Yes, sir.
my preference in any case is to resolve the case on the merits, particularly if somebody is willing, shows ultimately they're willing to respond to discovery. We can deal with lesser sanctions other than sort of throwing out the entire lawsuit or granting somebody judgment on their lawsuit if we can get to the merits. So
Sure, Your Honor. And yes, and I'd be happy to respond. With regard to the request for admissions, if done appropriately by the plaintiffs, what they would do is they would file a motion requesting permission to withdraw or amend those admissions. And pursuant to the statute, the court may grant that motion and give them that ability to do that. when the presentation of the merits will be subversed thereby, and secondarily, if the party that's obtaining the admissions fails to satisfy the court that the withdrawal of the admissions will prejudice their defense. So with regard to that first burden, to show that the presentation of the merits will be subversed, that burden is on the moving party, and that would be on the plaintiffs. So if they don't satisfy that burden, we don't even get over to the second problem. So now, with regard to what they have to show, the Court of Appeals has recognized that this isn't just a perfunctory satisfied prong. If the burden is of proof on the subject matter of the request will be on the moving party, which would be the plaintiffs here, then it must show that the pro-offer denial can be proved by admissible evidence, having just a modicum of credibility. In this case, not only have the plaintiffs not moved to withdraw those admissions, but they haven't offered any admissible evidence in this case that addresses specifically the items in the request for the admissions that they now seek to deny. Now, although opposing counsel has filed interrogatory responses with the court and provided some to us, when the court actually looks at those, they haven't complied with the motion to compel. First off, the requests for the admissions themselves are denied with a single sentence. There's no good faith effort to go through and actually respond to the request for admissions. And when you look at the request for admissions compared to the interrogatory request, which themselves are not verified, so those also would not be admissible evidence, when you actually look at some of the requests for admissions, for instance, which ask about damage to property, personal injuries and things of that nature, the interrogatories themselves at some points indicate that personal injuries are not being claimed, but they've been denied outright in the request for admission. So what we're seeing here, Your Honor, is plaintiffs haven't gone through and satisfied the statutory requirement to even begin to show the court that there's any sort of admissible evidence at all that would even support the denial. So what we would say in response to that is, to the extent that what they've done here can be asked of the court to basically consider a 9/11-36B motion and ask them to set these denials aside, they haven't gone through the proper steps to get where they need to do to show both us and the court that there's any evidence at all that would actually support what they're seeking to now deny. Now, again, I understand counsel has submitted interrogatory responses and things of that nature to the court. But again, these not only have not been verified, but contrary to the court's direction, there's still objections that remain in them, which although counsel says at the outset are withdrawn, there's still responses that are unresponded to. And also in response to the request for production of documents, absolutely nothing was produced in response to this. Now, I will admit that we have gotten evidence kind of throughout the course of this that plaintiffs may be relying on. But I think the defendants would have the right to know exactly what it is that opposing counsel is offering up to support his case. And part of the reason we've had an issue in this case resolving it to begin with is we just simply haven't got any evidence to support what they're claiming as damages and so on and so forth. So what I would say is, although I appreciate that the court generally likes to hear things on the merits, what we have here is a case where the plaintiffs didn't respond for requests for admission. Then when given an opportunity to do so, they sent out a blanket denial and then give up interrogatory responses and requests for admission responses that aren't in compliance with the court's motion to compel. So I don't think they've even made a good faith effort to try to comply with discovery, because assuming we were to just go on the documents that have been presented through evidence now, we can't even rely on any of that discovery information because, again, it's not verified. So at this point, there's actually no evidence before the court whatsoever at all that they even have a case, whether you want to rely on the request for admissions or the actual absence to provide any discovery responses that have any substance to them and that can be relied on. Because if we were to try to rely on these discovery responses at trial or in support of a summary judgment, then opposing counsel would have the argument to say, well, they're not verified, so they're really not even evidence, so you can't even rely on them. So at this point, Your Honor, where we find ourselves is requests for admissions that have been deemed admitted and plaintiffs trying to present some sort of evidence, but not even having admissible evidence to rebut the denials. So in the end, what we would say is they haven't gone through the proper steps to have these requests for admissions considered for being withdrawal or amended because there's simply no evidence to support them. So although they were given an opportunity, they didn't make a good faith attempt to do that and didn't provide the evidence that the court or the defendants would need to see that there's a good faith basis for denying those.
All right, thank you, Mr. Boyd. Mr. Alexander, you're in a tough spot here.
I am. It's a very tough spot. It's one that I can't remember finding myself in before in all my years of practice. I want to admit to this court, and I've worked with Mr. Boyd, that we did experience some problems in my office, and that I really wasn't aware of. We did get notice of the request, but then because of problems within the office, basically COVID problems with the staff and things of that nature, certain things just did not get in our system where it would come up on my calendar. So I really wasn't even aware of the motion to compel until I got the order. If you notice, I did respond to the motion to compel. I mean, that's not the way I practice law. It's not. I mean, I've been practicing for 37, 38 years. And my record would not reflect that. I don't ignore discovery. I don't ignore motions. And indeed, this is a refile case. And the interrogatories that were submitted, as best as I know, were basically the same interrogatories that we actually responded to previously in the original case. So it was some problems there that when I did see the order, by God's grace, it was still within time to respond. Now I stayed in my place, that's actually what happened. Okay. And so recognizing, like you say, the difficult spot that I was in, I did everything I could to respond within the time that the court, and I do appreciate, I've never come before you before. Okay. But I appreciate the order that said, hey, look here, get these responses in, and you got to do it by this time. By God's grace, I got the order. Never got the to this day. I did go on the docket and downloaded the motion and saw the brief and all like that once I got the order, and so I quickly prepared responses. Now, what counsel has stated that there remains objections. What I did, Your Honor, and much of it was because of the time that I had left once I found out about the motion through the order. And actually, I tried to locate the requests. So really, I operated blindly, assuming that the requests that were at issue now were the same requests that had been submitted in the previous case. So, because had I not done that, really, we've got 5 plaintiffs. Okay, there were requests made to each one of them individually, with the time that I actually had left in order to file within the time that was still left in the court's order. If I was starting from scratch, I might have been able to get 1, maybe 2 defendants done, but if I was starting from scratch, it just wouldn't have even happened. So what I did, I took the responses that we had already prepared previously, and I made a statement at the very beginning saying that all objections are hereby withdrawn that are stated here. It was a clerical procedure to try to get to meet the requirements of the order in terms of time, and in the fact that the judge's order stated that all objections have been waived, which of course that's what the law provides. And so at the top of the response that was filed is a explicit statement that any statement of objections that are set forth in this document is hereby withdrawn. So as it stands now, there are no objections. We have stated, we've given responses to everything that I know that was requested. Now, Mr. Boyd and I, we've worked this. We worked the original case, and we worked this case. And he has asked for documents even before the formal discovery. And I've sent the documents because we had some settlement discussions. And so he wanted the documents, and I provided every document that I have in this case has been provided to Mr. Boyd. And I stated in the response that all documents that were requested have been provided, period. Now, if they need to be provided again, I'm willing to do that. Now, with regards to the request for admission, it was my understanding that the court's order was giving it referenced, and I looked at the order. The order refers to it as discovery request. And so it was my understanding that the time to respond to the request for admissions also were encompassed in that order to say that, okay, delinquent plaintiff, delinquent lawyer, okay, here's your opportunity to get back in line. And like I said, now interesting in the previous case, in the original case, based on my records, there was not a request for admission in that particular case. But in this, and because of the time, the limit in terms of the time, we did deny the request. Now, I'm not looking to complicate this case. My client has suffered a wrong. They had Bell South to come in to install equipment. They drilled a hole in the wall and punctured a pipe, and that caused damage. That's what this case is about. Now, I admit, and if there's some sanction that the court would choose to assess on me, monetarily or otherwise, I'm willing to do. I accept responsibility, and I appreciate the rules of the court. I appreciate the law, and I just don't want my client to suffer because of my oversight. Now, in this particular situation, the evidence, there's clearly, if this case was being heard, even except for an argument that the request for admissions were not timely answered. And my understanding is that the order gave a certain time, and by God's grace, I thought I was back in order on that. I would ask that the court, if that's not the case, that the court allow me to file a motion to withdraw. Personally, I would like for the court to find that the order gave a certain time to respond, and that the plaintiffs did respond within that time, and therefore the requests have been denied at this particular time, and that to the extent that the motion for summary judgment relies upon the request for admissions, that no longer it can be a basis to support a motion for summary judgment. This is a straightforward case. I have just common everyday people who tried to get services, and instead of just getting those services, their property ended up being damaged. Bell South has refused to pay for those damages, And for that reason, I'm pleading with this court that, like I say, if I must be punished, please allow me to be punished. But please don't, I plead that the court not allow my clients to case to be taken away because of my oversight. I've had some problems just in even getting, I don't know, sometimes I guess it goes to junk, sometimes I guess it goes wherever. But even when we did get the request, because, the staff was just coming in and coming out, and, we ended up with this oversight. And I'm, like I say, I'm just glad I did see the order on the motion to compel, because otherwise then I guess I wouldn't even be in with that. And then even with this motion for summary judgment, I thought the motion for summary judgment was really mooted by the responses that were filed. And so that's my plea. That's my plea. My clients are ready. If the court will allow, we're ready to go to trial on this matter if the court will allow it.
You get the last word, Mr. Boyd.
Yes, Your Honor. I'd just like to respond directly to some things Mr. Alexander raised. First off, why defendants are not unsympathetic to his position of miscalendaring and things of that nature, I'd point the court to the case of InterSouth Properties versus Contractor Exchange, which is 199 Georgia App 726, which is a decision from the Court of Appeals, which basically recognizes that, unfortunately, things of miscalendaring and things of that nature, while unfortunate, are just not an excuse for not responding to discovery. Secondarily, what I would say is, although counsel says that they did provide responses to our other discoveries, such as interrogatory responses, things of that nature, to the extent he's trying to rely on those to say that they give support for the denial of the request for admissions, what I would say is he was half accurate in what he stated as when he said he provided discovery responses from the prior case. He did. He provided the initial responses. However, there were subsequent responses that were made throughout that case that were never incorporated in there. So it's difficult for us to know which real responses we're relying on. And secondarily, what I would say is, although he did say he withdrew the objections by making a simple statement at the beginning, if the court were to look at the discovery responses, you'll actually see that there's quite a handful that when you remove those objections, there's still simply no response. And again, they are unverified. So again, we come back to the fact that there's not a good faith effort to comply with the discovery request. And that's the same thing with the request for admissions. As I said, Your Honor, if counsel truly made a good faith effort to comply, that the interrogatory responses and the request for admission responses would match up. And that's simply not the case. So to the extent that the court would like to consider the order that was entered as an opportunity for opposing counsel to respond to those RFAs, I would state that, again, he simply hasn't complied with 9/11/36 because there's not a response to any particular RFA. There's just an outright denial. And as the rule requires, there's got to be a good faith effort to respond. And finally, well, two last things I would say. Counsel has essentially admitted that he's goofed up here. And again, we're not unsympathetic to that. It's basically admitted that, he's willing to take any sanction. And again, what we would say is, Your Honor, I mean, it's not really a sanction here. It's just simply the way that cases are ran. He hasn't properly responded to discovery. We're here with requests for admissions. The proper remedy here is to enter summary judgment in our favor. As he admitted, he's already had one chance in this case, and we got to trial and it was dismissed. Now, he says he's ready to proceed to trial now, but defendants aren't ready to proceed to trial because, again, we don't even have complete discovery responses that incorporate everything and that are verified. So again, now we're going to be at a position where we're going to be hamstrung because we've been asking for this stuff, haven't got it, but he says he wants to go to trial, and we're going to basically be defending a case that's blind. So that's why we have written discovery. That's why we served the request that we did. And unfortunately, we've gotten here because counsel hasn't really responded to any of the discovery. So I would, again, rely on the fact that there hasn't been a good faith effort to respond to the request for admissions. So there's still continued to be deemed admitted. Either if the court granted him additional time to do it, he hasn't made a good faith effort to comply. And what we'd actually argue is that he should have filed the proper motion under 91136B, made the showing, which he had an opportunity to do coming into today, and has further demonstrated that he can't make that showing by any admissible evidence. So that's, unless the court has any questions, that's all we would have on our position, Your Honor.
All right, so I think I have discretion here as to proper remedy. Certainly, Mr. Alexander's been forthcoming about, the issues at his own practice that have led us to this point. And, if I was convinced that there weren't any merits to this, I would not hesitate to grant summary judgment. But on the record I have, I'm not convinced that there's not any merit. I'm hearing that a good amount of discovery was had. And perhaps BellSouth doesn't know all the positions of the plaintiffs in this case, but it's notable that there hasn't been a motion for summary judgment on the merits. And if in fact there was no evidence, I would expect to see a merits argument. On the same token, if there really are merits here, I would have expected to see something from the plaintiff in any of the filings in response to this motion for summary judgment that there were merits. And I don't see that. So it's a difficult position where I think there may be merits out there, but I don't see what those merits are. And Mr. Alexander, I take your comment about the nature of my order. I think the ordering response to discovery could be reasonably be interpreted as an order to respond to the request for admissions and giving you opportunity to do that. But that's not what it was. It was in response to their particular motion. So I am going to give you an opportunity to make the required showing under the Civil Practice Act to withdraw your admissions, which means you're going to have to show merits.
Yes.
If you can make that showing, you're going to have 10 business days to do that. So 2 weeks from this Friday, that would be the 16th, to make your showing with admissible evidence that there are merits here. If you can make that showing, I'm going to deny the motion I'm going to let you withdraw admissions and deny the motion for summary judgment. If you can't make that showing, and I'm going to allow Mr. Boyd to have a response to that, to your request. If ultimately I find that showing hasn't been made, then the motion for summary judgment is going to be granted and the case is going to be dismissed.
Thank you, Your Honor.
So this is your last opportunity to put up or be sent packing.
I greatly appreciate that.
And Mr. Boyd, you did not specifically request monetary sanctions. I think monetary sanctions may be in order for having to submit the motion for summary judgment. I'm not going to order that at this point, but I'll let you have a chance to talk with Mr. Alexander about that, what your expenses were in preparing the motion for summary judgment. I think given the record you had, I think it was appropriate for you to submit a motion for summary judgment. And it's not your fault in any way that there were issues happening on plaintiff's attorney's side. So I'll let you have those private negotiations. If you're able to work it out, then I don't have to do anything else from there. But if you're not able to work it out, then we can talk about that.
Okay. Yeah, and I
Yes,
will
sir.
say,
Thank you, Your Honor.
I'll say to Mr. Boyd, we will, within reason, we'll be glad to cover your expenses. Thank you.
Yes, sir. We'll be happy to talk to you about that.
Thank you.
All right. So That's my order. I don't know that, that we need to put that in writing. It's on the record. We'll go, because I haven't ruled on the motion for summary judgment yet. I'm reserving ruling on the motion, and I'm anticipating a motion to withdraw admissions on or before the 16th.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
May I be excused?
You may
May we
be
be
excused.
excused?
Thank you, counsel.
Thank
Y'all
you.
have a good weekend.
Thank you.
All right. Bye now.
You as well, sir.
All right. Thank you. And y'all have a good weekend.
Thank you. Judge, you also have a 1 o'clock, right?
I believe the 1 o'clock has been canceled.
Okay, okay, great. Thank you for letting us know, and you have a great weekend.
All
Happy
right.
Easter, everybody.